Can I just follow up by asking, I guess the lower courts really focused on ripeness, which is a theory that involves the timing of your lawsuit. And I guess I'm wondering, even if we agree that there is, your constitutional rights are arguably burdened, is it really occurring at the moment of receipt of the subpoena? I mean, I think there's part of this dispute is about when those burdens actually fall on an association. And it feels a little odd to me that from the moment the subpoena comes in, especially if we credit your view that it's unlawful and that they're not allowed to ask you for these things, I wonder whether the burden is really happening at that moment.
With respect, Your Honor, I think an ordinary nonprofit receiving a subpoena commanding compliance on pain of contempt would find that to be chilling. In addition,
I'm not talking about the chilling theory. I'm talking about the pre-enforcement theory.
So either of them suffice here. But to address your question on pre-enforcement, the question is whether when the subpoena was delivered, there's a credible threat of enforcement. That credible threat is clear on the face of the subpoena.
But what if you're right? What if you're right that the subpoena is bogus? I guess I'm a little confused as to how this works, because if you're right that the subpoena is wrong, is unlawful, then I guess we would suspect or expect that the state court would agree with you, and so there really isn't a credible threat that it's going to be enforced.
So two responses, Your Honor. Under this court's cases like Steffel and Dombrowski, the ultimate success of a constitutional challenge does not diminish the credible threat of enforcement. This court has never required that a plaintiff show that he has a really bad case in order to get into federal court. And second, Your Honor, Section 1983, the Reconstruction Congress clearly provided plaintiffs who have been harmed by alleged state malfeasance a choice between federal and state court. First choice is simply asking for its day in federal court here. We think it satisfies two theories of Article III standing. And with respect to the sorts of things that could happen later in the case, the Attorney General, for example, talks about negotiation. But negotiation can always occur in every case. The courts can easily handle those sorts of things through their docket management tools, but it doesn't take away the fact that Article III standing exists. In fact, to take this case as an example, the Attorney General did not narrow his subpoena until the Third Circuit granted expedited review. To find the negotiation somehow obviates Article III would give the government the whip hand in every one of these cases.